So picture a scenario that plays out in, well, corporate boardrooms every single day.
Oh, absolutely. All the time.
Right. You are sitting there looking at a multi-million dollar global contract. Maybe it's, a vital joint venture or some massive cross-border supply chain agreement.
Yeah, the high stakes stuff.
Exactly. And you've just hit an absolute brick wall with your international partner. Deliveries have completely stopped. Invoices are just being ignored. The whole deal is effectively
Which
paralyzed.
is incredibly stressful.
It is. And for anyone who has been in that seat, the traditional reflex is, well, it's usually immediate legal warfare. You mobilize the litigation team, you file the lawsuits, and you brace your balance sheet for years of incredibly expensive, highly public maneuvering in a courtroom.
Right. Which, I mean, let's be honest, is a strategy that almost guarantees the permanent destruction of that underlying business relationship.
Yeah, totally burns the bridge.
It really does.
Yeah.
Litigation is inherently backward looking.
Mhm.
You're asking a judge to look at the wreckage of a contract, figure out who breached it, and award damages. It's a zero-sum game.
Mhm.
You might secure a financial judgment in 3 years, but you have lost a critical supplier or a key market partner today.
And that is exactly why we are here. Welcome to today's deep dive. Our mission today is to unpack a highly strategic alternative to that scorched earth approach, specifically the International Chamber of Commerce, or ICC mediation process.
Such a fascinating mechanism.
It really is. We are analyzing the mechanics of how this functions, not just as like a legal safety valve, but as a critical business tool.
Right.
We're going to explore everything from the structural philosophy of neutral facilitation to the concrete steps of actually initiating a request and how you can actually leverage the ICC to bring a totally hostile partner to the negotiating table.
Yeah, and the real utility of this process comes down to its universal accessibility.
How do you mean?
Well, the ICC rules are designed so that uh, private companies, states, state-owned entities, international organizations, and even individuals can utilize this framework. Anyone can use it.
Oh, wow.
Yeah. It is fundamentally about shifting the focus from, who is legally at fault to how do we actually solve this operational problem and get back to business?
Okay, let's start with the operational core of this entire framework then, the mediator. Because when people hear mediation, they sometimes imagine, I don't know, a sort of corporate therapy session.
Yeah, a lot of people think that.
Right, which sounds a bit soft for a high-stakes commercial dispute. But functionally, this neutral facilitator operates more like maybe a diplomatic back channel or a deal architect,
That's a great way to put it.
because they aren't there to issue a binding verdict.
Far from it. A mediator under the ICC rules possesses literally zero power to impose the decision. That is the defining feature of the whole process.
Okay, wait, zero power.
Zero. Yeah. I mean, in arbitration or litigation, parties are handing their agency over to a third party. The judge holds the gavel. But in mediation, the process is entirely consensual.
I see. So what do they actually do then?
The mediator's role is to stress test each party's assumptions. They conduct private, confidential sessions, they're often called caucuses, where they push executives to look past their immediate legal posturing.
Right, the surface level arguments.
Exactly. They help them identify their actual underlying commercial interests to find that win-win.
Okay, but I want to examine the reality of those power dynamics for a second. If you have, say, a massive multinational conglomerate on one side and a highly specialized mid-sized component manufacturer on the other,
A classic David and Goliath.
right, the conglomerate can easily afford to bleed the smaller company dry in court. Why would they voluntarily sit down and genuinely negotiate? The incentive structure just seems skewed if one party thrives on attrition.
That's a really fair question. But the incentive to mediate in that scenario often stems from risk management and control. Yeah, because even for a corporate giant, litigation is a roll of the dice. You are risking a judge or a jury fundamentally misunderstanding the highly technical nuances of your specific industry.
Ah, yeah, that makes sense. A judge isn't an expert in microchip supply chains.
Exactly. Furthermore, a court order is a blunt instrument. It can award damages, sure, but it cannot rewrite a delivery schedule to actually fix a broken supply chain. Mediation allows both parties to maintain absolute control over the outcome.
Meaning you don't agree unless it works for you.
Right. You only sign a settlement if it makes better business sense than your alternatives. What's fascinating here is if you put yourself in the shoes of a CEO, would you rather risk a judge misunderstanding your industry or keep the power in your own hands?
definitely keep the power. And I imagine the control aspect also plays heavily into compliance, right?
Factor, yeah.
Because if executives engineer their own solution, they are, infinitely more likely to actually execute on it, rather than constantly searching for loopholes in a court order they were forced to swallow.
The data strongly supports exactly that. Voluntarily negotiated settlements have a remarkably high rate of natural compliance.
Makes sense.
And for the multinational, in your example, preserving a relationship with a highly specialized, reliable supplier is often worth way more to their long-term bottom line than crushing them in court.
Because then they'd have to rebuild a supply chain from scratch, which is a nightmare.
Exactly. So mediation provides a structured environment to isolate the immediate conflict from the broader operational relationship.
Okay, so understanding that strategic value, let's transition and actually unpack the mechanics of triggering this process. If a general counsel or a VP decides they need to deploy this tool, how does the initiation phase actually work?
It's actually designed to be incredibly frictionless.
Right, because it's heavily reliant on electronic filings, but there is a specific structural narrative to how you frame the request, from what I read.
Yes. So the moving party drafts a request for mediation. Now, this must be in writing, and the ICC actually provides specific forms to standardize the intake.
And those are available in English and French, right?
Correct. You get the form by emailing them at mediation@iccwbo.org, and then you submit it electronically to the ICC International Center for ADR.
You can email it back there, or to adr@iccwbo.org, or even fax it, right?
Yeah, though most just use email these days.
And when we look at the requirements for that request, it's not just some basic intake form. You are effectively laying out your opening strategic position.
You really are setting the stage.
Right, because you have to include contact details, obviously, but you also provide a comprehensive description of the dispute, the estimated financial value of what's at stake, and crucially, your proposals for the logistical framework.
Things like the location, the language of the proceedings.
Yeah, and the specific attributes you require in a mediator.
Exactly. By stating the attributes you want, maybe someone with a deep background in maritime law or, renewable energy patents, you are signaling to the center the exact nature of the expertise required to untangle the mess.
Now, there is a procedural quirk in the source material regarding physical documentation that I want to highlight, just to be safe.
Oh, the hard copies.
Yeah. While the primary engine of this process is digital, the rules are slightly contradictory but lean toward caution. One part says a hard copy must also be provided to their physical headquarters in Paris.
Right.
But then another note clarifies you only need a sufficient number of hard copies if a formal notification in hard copy is actually requested by the parties or required by local law.
It highlights the reality that international business still has to bridge the gap between digital efficiency and, legacy legal requirements in certain jurisdictions.
Right. Definitely something to double check with your legal team. And what about the other party? Did they just get an email from the ICC out of the blue?
Well, this is a critical detail for compliance. Simultaneously with submitting the request to the center, the filing party is obligated to send a copy directly to the other party.
Assuming it's not a joint filing, obviously.
Assuming it's not a joint filing? Yeah. The ICC places a high premium on absolute transparency from day one. There are no secret filings designed to blindside a partner.
Which brings us to the financial gateway. Step 6. The rules require a non-refundable filing fee to accompany the request.
$3,000.
And the request isn't even considered complete until that clears, right?
Exactly. The center will not process the paperwork until they have that filing fee.
Wait, I have to ask. Is that all it costs to solve a massive global dispute? $3,000. In the context of a $100 million infrastructure dispute, that is practically a rounding error.
Well, it functions as a highly effective filter. That $3,000 is basically an earnest money deposit. It proves to the center and to the opposing party that you are not just posturing, you actually have skin in the game.
Okay, but surely that's not the final bill.
Right, no, the $3,000 is just to open the door and cover the initial intake. Once the proceedings formally commence, the financial structure shifts to a system of deposits.
To cover the center's administrative expenses and the mediator's fees.
Exactly. And the administrative expenses operate on a predefined sliding scale based on the total value of the dispute.
Which provides immense budget predictability for corporate counsel.
It really does. For example, if the dispute is under $200,000, the administrative fee is capped at $5,000.
And even if you're arguing over a contract worth more than $100 million, The center's administrative fee maxes out at $30,000.
Right. Which, when you compare a maximum of 30 grand to what a top-tier litigation firm charges for, say, a single week of electronic discovery.
Oh, it's not even close. The cost-benefit analysis is heavily skewed in favor of mediation.
Absolutely. And the mediator's fees are handled with equal rigor to preserve neutrality. They're usually based on an hourly rate.
But who sets that rate?
The center does.
Yeah.
Unless everyone explicitly agrees to a single fixed fee, the hourly rate is fixed exclusively by the center, based on the complexity of the dispute, not by the mediator negotiating directly with the parties.
Ah, I see. That prevents any subtle financial leverage. Like, a party cannot attempt to curry favor by offering to double the mediator's rate behind closed doors.
Exactly. The center acts as the financial clearinghouse. They typically require both parties to split the deposits equally down the middle, keeping the mediator entirely insulated from the economics of the conflict.
Okay, so filing that request is incredibly straightforward. If both companies had the foresight to include an ICC mediation clause in their original contract years ago.
Right, that falls under Article 2 of the rules. They've pre-committed to the process.
But here's where it gets really interesting.
Yeah.
The reality of international business is that contracts are often drafted in a hurry, or they use legacy templates that lack those specific clauses. If there is no pre-existing agreement to mediate, how do you initiate this without looking weak?
That's the cold call scenario.
Right, because in high-stakes corporate disputes, unilaterally reaching out to a hostile partner and asking for a sit-down is often perceived as blinking first. It signals that you might not be confident in your legal position.
That ego dynamic is precisely what Article 3 of the ICC rules is designed to circumvent.
How does Article 3 work?
It empowers one party to unilaterally propose mediation to a partner, even in the complete absence of a prior agreement. You just file the request, you outline the dispute, you pay the $3 grand, and the ICC takes over the approach.
So the ICC effectively becomes a clearinghouse for corporate ego. You aren't calling your furious vendor and begging them to talk. You are paying the International Chamber of Commerce to formally and neutrally invite them to a structured dialogue.
Exactly. If we connect this to the bigger picture, the ICC is essentially lending its prestige and neutrality to help you bring a reluctant partner to the negotiating table. They act as a highly prestigious buffer.
And they actively assist in considering it, right?
Oh, yeah. Their role goes far beyond acting as a courier. If you're dealing with a business partner in a jurisdiction where mediation isn't common practice, they might view the request with deep suspicion, assuming it's some sort of legal trap.
Right. What are they trying to pull?
Exactly. So the center's staff will actually step in and interface with the opposing party. They might arrange joint teleconferences or hold private, separate discussions with the reluctant party to explain the benefits.
They explain that there's no binding risk.
Yes, and answer procedural questions.
Yeah.
You are essentially renting their global prestige to legitimize the invitation.
But there has to be a mechanism to prevent that invitation from becoming an endless distraction, right? Because you cannot have a business unit paralyzed for months waiting to see if a vendor feels like talking.
The rules impose strict deadlines. The clock is ticking. Under Article 3, the opposing party has exactly 15 days from the date the center receives the problem. Request to provide a response.
Wow, 15 days is fast.
It is. Now, the center has the discretion to extend that window if they see genuine progress, but the baseline is a tight 15-day countdown.
It forces the other side's executive team to make a definitive choice, engage in a low-risk dialogue, or commit to the expensive path of litigation. And if they agree...
If they say yes, the proceedings officially commence on the date the center dispatches written confirmation of the agreement.
And if they say no, or just ignore the ICC entirely...
If they say no, or the 15 days expire without an agreement, the proceedings simply do not commence. The center formally notifies all parties, the file is closed, and you are entirely free to escalate to arbitration or court.
Having at least demonstrated to any future judge that you made a good faith effort to resolve the matter amicably.
Exactly. It's a win-win procedurally.
Okay, let's look at the scenario where the mechanism works. The other party agrees, either via an Article 2 contract clause or persuaded by the ICC under Article 3. The paperwork is filed, the deposits are paid. What actually happens in the room?
Right, the procedure itself.
Because how do you prevent a hostile party from immediately sabotaging the logistics before you even get in the room? Like, one side demands to meet in London and negotiate in English, the other side insists on Paris and French.
Logistical sabotage is a classic stalling tactic, And if they hit a deadlock there, the mediation could collapse before a mediator is even appointed.
Right.
But the ICC rules anticipate this. Under Article 4, if the parties cannot agree on the physical location of the meetings or the language to be used, the center is empowered to step in and make a binding determination on those points.
That is such a brilliant procedural bypass. It just completely removes the low-hanging fruit of early procedural sabotage.
It really does. It handles the administrative friction so the mediator doesn't have to alienate anyone on day one by ruling on where they sit.
Speaking of the mediator, how do they get picked?
Ideally, the parties jointly nominate an individual they both respect. If they can't agree, the center intervenes again. They'll either directly appoint someone from their global network or provide a curated list for the parties to rank.
And once they're locked in, the pacing is incredibly aggressive from what I read.
Oh, very. There's a prompt first discussion, usually a video call between the mediator and the parties, to custom design this specific procedure.
They define the timeline, documentation, formats.
Yeah, and the mediator formalizes it in a written note. The whole thing is incredibly efficient. The average duration of an ICC mediation is approximately 4 months total.
4 months.
And the actual substantive meetings, whether physical or virtual, typically last just 1 to 2 intensive days.
Okay, that timeline is great, but it raises a huge practical question for me. What if the mediation is just a stalling tactic? Like, they know they owe $50 million, they're not going to pay, and they're just using this 4-month window to hide assets.
Right.
Does initiating this process frees our right to actually sue them?
That is the most common hesitation corporate counsel have. But the ICC addresses it head-on in Article 10.2, a crucial safeguard.
What does it say?
Unless the parties have explicitly agreed otherwise, commencing an ICC mediation does not prevent a party from simultaneously initiating parallel arbitration or judicial proceedings.
Oh, wow. Okay, so the two tracks can literally run concurrently.
Precisely. You do not surrender your legal leverage by attempting a commercial resolution. You can have executives negotiating on Tuesday and your lawyers filing a lawsuit on Wednesday.
But doesn't that make the mediation room kind of dangerous? Like, if an executive admits they're facing a cash flow crisis during the mediation, couldn't that be weaponized in the parallel court case?
It could, which is why the framework has an ironclad firewall. Article 9 outlines strict confidentiality protocols.
How strict?
Very. And it's coupled with Article 10.3, which states that unless agreed otherwise, the individual who serves as your mediator is strictly prohibited from subsequently acting as a judge, an arbitrator, or even an expert witness in the same dispute.
Ah, so the mediator can't take off their neutral hat, put on a judge's robe, and use your confidential admissions to rule against you.
Exactly. The process is a legally protected bubble. Any documents produced specifically for the mediation, settlement offers, admissions of fault, none of that is admissible in subsequent litigation.
And the ultimate goal of all this, if successful, is a contractually binding settlement agreement.
Yes. It replaces a messy conflict with a defined, forward-looking contract.
So what does this all mean for you listening? Well, when you are facing a massive cross-border commercial deadlock, the immediate leap to litigation might just be a failure of strategic imagination.
Beautifully said.
Thanks. ICC mediation is a highly flexible, deeply confidential process focused on preserving business relationships. You literally start it with an email and a $3,000 fee.
Yep.
And even without a prior contract clause, the ICC will help you invite the other side to the table without compromising your legal leverage. It reorients the whole conflict toward finding a win-win solution.
It is a profound shift. And before we go, there is a regulatory evolution in the source material that makes this even more potent.
Oh, what's that?
Historically, a mediated settlement was simply a contract. If they breached it, you had to sue them for breach of contract. But a 2008 European Union directive actually allows mediated settlement agreements to be recognized and enforced across member states like formal court judgments.
Wait, really? So automatic enforcement?
Yes. It removes the final hurdle of enforceability within the EU.
That is massive.
It is. So here's a thought for you to ponder as we wrap up. As global trade becomes increasingly interconnected, if more regions adopt automatic cross-border enforcement for mediated settlements like the EU did, could this collaborative win-win mediation model eventually make adversarial court battles entirely obsolete for international business?
Man, what a fascinating question to leave on. If the enforcement risk drops to zero, the strategic value of mediation becomes undeniably superior. Well, thank you for joining us on this deep dive into the mechanics governing global business, and we'll catch you on the next deep dive.
Thanks for watching. Please subscribe and see you next time.